Hi, we're just going to be wrapping up our last presentation with an attorney, a family law attorney, Christian Lapham. He is with a firm out of Arlington, Virginia, and it's Bean Kinney Corman. So we've been working with them for many years. He always delivers great presentations, and we're going to kind of jump into it. So welcome, Christian.
Thank you so much, Elise. And thank you to Argent Bridge for giving us this opportunity. Just a quick plug for Argent Bridge. You guys have been fantastic to work with. I've been working with first Diane Nolan and then Cecile and Elise for the last, 9 or 10 years. When I hosted a Second Saturday program, Diane was so generous with her time, and there really is a difference when you have a financial partner who has a background in divorce-related issues. So we routinely refer clients to Argent Bridge. So thank you guys so much for.
And we appreciate it, and we feel the same way about all of our family law attorneys at Bean Kinney Corman. So thank you for joining us.
Absolutely, and it really does take a team. Your attorney is important, but your financial professional is equally important, and you've got a great team there. So let me dive in and make sure I am.
Christian's bringing up his slides. I'll just reiterate that building the team is definitely what Discovery to Divorce, Done with Divorce is all about. So just kind of building the right team is going to carry you through getting divorced and then post-divorce.
Okay, Elise,
Great.
thank you again so much.
Thank
So
you.
like Elise said, my name is Christian Lapham. I'm one of the family law attorneys and partners at Bean Kinney and Corman. I've been practicing family law for now 21 years, literally thousands of cases. Many have been litigated, many have been settled. So what I'm going to be talking about today, which is an introduction to the separation and divorce process, is kind of a crash course of what I think you need to know in that initial consult, and as you're kind of starting this process. By the way, for those visual learners out there in video land, I also prepared a toolkit, which Elise has been so generous to include on the Argent Bridge website. It's called the Divorce Toolkit, and it's got approximately 20 pages of information. A lot of it's redundant to what I'm going to be talking about today, but does kind of set forth the law as it relates to separation, fault-based divorce, child support, child custody, spousal support, asset division, really, all the stuff that you would be dealing with in a separation and divorce process is in there, at least provide some good starting considerations. And by the way, what I'm going to be talking about today is an introduction to the separation and divorce process in Virginia. Domestic relations law is very state specific. So if you are starting this journey, or a loved one or a friend is starting this journey in the District of Columbia or Maryland, I would strongly encourage you to seek assistance from an attorney who is barred in the District of Columbia or Maryland. There is some overlap in terms of how the courts view these issues in other states, but it is not consistently redundant. So you really want to talk to somebody who's barred in that jurisdiction. So as it relates to Virginia, I'm just going to jump right in and get going with the kinds of divorce in Virginia. So in Virginia, you basically have, like in many states, no fault and fault-based divorce, and no fault, which is really more of a term you hear in other states. In Virginia, no fault translates to a divorce based upon separation grounds. What is required in Virginia, if you are filing on separation grounds, is that if you have minor children, that you and your spouse have to be living separate and apart for a period in excess of 1 year before you can file for divorce. If you don't have minor children and you have a separation and property settlement agreement, and we'll talk in a couple minutes about what that means, then you can file after 6 months. So 6 months and a day from the date of separation. Now, what does it mean to be separated in Virginia? In Virginia, you do not file for legal separation. It is a more or less a factual determination that the court makes or the parties agree upon. And the date of separation is the day that one or both of the parties has the permanent intent to be living separate and apart from one another. Now, what does that mean? Because sometimes these legal definitions are hard to kind of unpack for non-attorneys. So what that really means is someone has moved out, or if both parties are still living under the same roof, one party has left the marital bedroom. They're not sharing a bed any longer. They're not having a physical relationship. They're not going out on dates. They're not sitting on the couch watching their wedding video and reminiscing. They're really living under the same roof like roommates. That's kind of the test. The court will look at other things like, are the parties going on trips together? Are they sharing a bank account? But the big ones are physical relationship, dating, marriage counseling. Are they working on things? Or have they kind of given up, and are they living like roommates? So that's separation in a nutshell. It's got to be continuous and uninterrupted through the date of filing, and even further through the date of divorce. On the other side, there are the fault grounds for divorce in Virginia are very much alive and well. That includes, but is not limited to, desertion, cruelty, and adultery. Desertion is when one party leaves the marital residence, and it actually has to include a departure from the marital residence without the consent of the other party, with the intent to stay permanently away. So if somebody moves out, moves back in, that's not desertion. If somebody moves out because the parties agree that they can move out, that's also not desertion. So it's really got to be that leaving without the consent of the other party. Cruelty is predominantly the abuse factor or fault ground in Virginia. It's usually physical abuse. It can be emotional or mental abuse, but it's got to be some really, what I tell people is it's got to be really bad. A lot of people feel that they are abused in their relationship, but the courts are going to be pretty strict and strictly construe whatever the facts are and in deciding whether or not to grant a divorce based upon cruelty. Adultery, which is very much alive and well in Virginia, both as a fault ground and as an act, I can tell you from experience professionally, is when somebody is having a physical sexual relationship with an individual who is not their spouse anytime before the divorce is final. So can it happen after you're separated? Absolutely. Does it include an emotional affair, a card that somebody finds that their spouse has professed their undying love to a coworker? No, that's not adultery. Adultery is a physical sexual relationship with someone who is not your spouse. All right. So when you're going through this process and let's say that you're separated, there's adultery, possibly cruelty. What do you file and why? So let's talk about the benefits and the detriments of filing on separation grounds versus fault. I generally tell people that in most cases, filing on separation grounds makes more sense. Pursuing a divorce based upon separation grounds makes more sense. And they're really a couple very good reasons. And, I've listed the pros of the separation-based divorce. It's easier, it's quicker, it's less expensive, it's less emotional, focuses issues on the future, promotes settlement, but really it's that less expensive and less emotional and easier are by far the biggest advantages. And when we talk about expense, your average fault-based divorce, where a judge is deciding all the issues in your case, is going to range in cost from about $75,000 to $100,000 per side on the low end to $200,000 to $300,000 on the higher end, and can even exceed those numbers. So if people file on fault and have a judge decide everything in their case, so you're going to trial on all issues, you could have a $300,000 divorce per side. And I think it's important to tell people those numbers right up front, because you pay a retainer to an attorney, it's probably $5,000 or $10,000, and emotionally, you kind of think, okay, $10,000. Now I have a lawyer, and I'm ready to go. But the problem is in a month or 2 months, you're going to be asked for another retainer and another retainer and another retainer, and before you know it, you've spent $90,000. So, those are some pretty astounding numbers. So let's talk about the separation-based divorce. Separation-based divorce, will typically cost anywhere between $5,000 to $10,000 per side on the low end, to maybe $15,000 to $25,000 on the higher end. They can be more, but that's a fairly good range. So obviously much less expensive. Most family law attorneys have a majority of their cases in this kind of settlement posture. They're not fault-based divorce cases, and they're not as expensive. But I could have 15 to 20 relatively uncontested, no fault type cases, and then I could have 3 fault divorce, litigation cases, and those 3 could generate as much work and as much money as the other 20 combined. So try to stay within the 20, not within the 3, would be my advice. Let's talk about when it makes sense to file a fault-based divorce. There are really 2 good reasons to file a fault-based divorce. In certain circumstances, you need to get into court quickly. You can't afford to discuss settlement. You can't afford to wait for your spouse to come to their senses and agree to do XYZ. You need the help of the judge immediately. That could be, for example, a situation in which your spouse, who may make more money, decides to stop paying the mortgage, or decides to take your kids and move to Nebraska, or decides to do a whole host of things which are alarming and are emergencies, and you've got to file now because you need the help of the court now. That's a really good reason to file immediately. Another good reason to file on fault is that, and it's kind of here under the no fault con. And let me skip ahead a little bit. If you have exposure to potentially pay spousal support, you may want to consider filing on fault, specifically on adultery, if there is a basis for that, to bar your spouse from receiving spousal support, or at least to create leverage that will drive that spousal support number down. You're not going to have as much leverage strategically if you're pursuing a divorce based upon separation grounds. So that's another very good reason to file based upon fault. But I would say, again, most people file on separation grounds. Most people try to work their case out first before they even file. And again, some very, very good reasons, financial, emotional, and time-wise, to do that. Let's talk for a second about child support. This is a relatively, there's some more complicated subjects and topics in family law. Child support is not one of them. It is very straightforward, and it's intentionally pretty straightforward. Child support's almost always done by guidelines. I don't list the guideline statute here, but it's Virginia Code 20-108.2. If anybody really wants to do some very boring reading online. If you Google Virginia child support calculator, there are a number of good online calculators if you want to try to figure out what your child support obligation would be or what your spouse's child support obligation would be. But basically speaking, the formula is predicated on your income, your spouse's income, the work-related childcare costs attributable to the children. Now, why isn't it just childcare costs, period? Well, the statute's very clear. They've got to be work-related. So if one parent works inside the home, is a stay-at-home parent, and the child or children have a nanny or are sent off to daycare, that daycare will not count for child support purposes. Additionally, the marginal cost of providing health insurance for the child or children, again, that's not the total cost of monthly health insurance, but the cost attributable to the kids. And finally, the number of days the parents have with the children. A day is defined as a 24-hour period. And if it is includes an overnight, but is not a full 24 hours, it is half of the day. So you kind of plug all those things into the formula and you get a child support amount. There is a basis to deviate from the child support guidelines. That's in Virginia Code 20-108.1. If there's a unique circumstance attributable to the child, a special need, some other kind of unique circumstance for the family, that will sometimes be considered a basis to deviate from those guidelines. But quite honestly, courts very rarely do. A lot of people come to court saying that their family is special, their child is somehow unique or special. Judges are very skeptical about that. So as a kind of a strategy issue, I don't generally advise people to pursue deviations from the guidelines, because the only guarantee when you do that is you're going to spend a significant amount of money on your attorney to seek a deviation, and more likely than not, you're not going to receive that deviation. All right, when does the child support obligation begin? In Virginia, it begins when someone files for child support. It will be retroactive to that date. So on an initial request, the actual filing starts the clock for that. When does it end? It ends when a child turns 18, but if they're still living at home on their 18th birthday, it ends when they graduate from high school or turn 19, whichever is first to occur. That is a long way of saying for most kids, it ends with their high school graduation, assuming that they are 18. Child support is possible to be extended past that period if there is some sort of mental or physical impairment that renders the child or children incapable of being self-supporting. But this is a really high bar. It's got to be like, some sort of significant special need or impairment that renders the child totally incapable of any sort of financial independence. This is not a failure to launch situation where the child is, finding themselves or lazy or pursuing a philosophy degree. That's not a basis for child support to be extended. I mean, this is a really, there is a mental or physical condition that renders that child essentially unemployable now and possibly in the future. Child support is modifiable based upon a material change in circumstances. That would include a change in income, the termination of work-related childcare. All those things are pretty easy modification bases. All right, spousal support. I said child support was easy. Spousal support is hard. Spousal support is that area where guys like me and ladies who do what I do earn our money, because it is a notoriously ambiguous topic in Virginia. I say here there is a formula. I also say there is no formula for a final spousal support obligation, although in Fairfax sometimes the judges will apply the formula. And I'll get into what that formula is in a second. But if we're talking about spousal support that would be pursued in the juvenile domestic relations court, so not as part of a divorce process, or temporary spousal support for households with an income of less than $10,000. In both of those circumstances, the court will often apply the following formula. And that formula is you take the higher earning party's monthly gross income and you multiply that by 26%. And then you subtract from that the recipient's monthly gross income multiplied by 58%. And if that's a positive number, that would be the monthly spousal support obligation. That's if there are kids. If there are no kids, same concept, but you just take the payor's monthly gross income times 27%, and you subtract from that the payee's gross income times 50%. Those numbers used to be 26 and 58 with kids, and 30, 50, I'm sorry, 28 and 58 with kids, and 30 and 50 without kids. They changed those percentages because in 2019, the spousal support deduction and taxability as income was phased out. So they had to adjust those figures. Again, I'll give you the code section for some late night reading. That's Virginia Code 20-107.1. It lists a lot of factors the courts can use to determine spousal support. But the court will often, at least in the Northern Virginia jurisdictions, apply this formula as kind of a gut check. Like, okay, let's see what the formula gives to give me a starting point for spousal support. The other method is what's called the income and expense method, where the court will tally up the party's income, net income, and monthly expenses. And if the expenses exceed the monthly income, the monthly net income, then that would be the spousal support amount. That is often the method that courts use at a final hearing. So you'll hear sometimes of something called an income and expense worksheet. That's basically exactly that, just a summary of the income and expenses and what's needed on a monthly basis for the person to meet their needs. Courts want to maintain the marital standard of living to the best of their ability. There will often be an argument about what the marital standard of living actually was, and spousal support considers the payor's ability to pay and is balanced with the financial need of the recipient. So that's amount. In terms of duration, again, not a lot of guidance in the statute as to duration, but the practitioners in this area will tell you that they're going to look at a lot of the same factors. What's the earning capacity, what's the length of the marriage, etc. All else being equal, kind of a not a rule of thumb, but a trend that we see is if the marriage is less than 20 years, and this does vary, by the way, county to county in Northern Virginia. In Arlington and Fairfax, you're going to see typically a shorter duration of spousal support many times than you will see in Loudoun County. And by the way, even within those counties, it's very judge specific, the amount and duration of spousal support. But if the marriage in particularly in Arlington and Fairfax, if the marriage is less than 20 years old. So, let's say 15 years, the practitioners who do this tell their clients, okay, well, you're probably looking at plus or minus half the length of the marriage if it's a less than 20-year marriage, in terms of a spousal support duration. So if it's 15 years, 7.5 years, could be 6 years, could be 8 years, could be 5 years, but that's at least a good starting point for people to think about when they're trying to figure out what the duration of spousal support may be. If you get over 20 years, in many circumstances, you're looking at what's called a permanent duration, which is really kind of a misnomer. Spousal support durations are less and less permanent, even of the permanent awards. And what I mean by that is spousal support is typically, if it's awarded by a judge, inherently modifiable. And recent changes in the law suggest that when somebody retires after they are at the age where they are full Social Security eligible, the court is going to determine that retirement is a material change in circumstances. Now, if they retire and somehow some pension kicks in and they're actually making just as much money or almost as much money or even more money than they were making when they weren't retired, which is admittedly rare, but if that were true, that would not be a basis to reduce or eliminate spousal support. But if their ability to pay has drastically gone down because they've retired at age, 66 and a half, 67 or greater, again, that full Social Security age, then the court's in many cases going to reduce or terminate that support obligation. All right, what does if spousal support is modifiable, when is it able to be terminated or terminable? The death of either party, the remarriage of the individual who is receiving spousal support, and if the recipient of spousal support lives in a relationship analogous to a marriage for longer than a year, that would be a basis to terminate spousal support. That last one it's a difficult thing to prove. You got to prove that that relationship is analogous to a marriage. You've got to prove that period of cohabitation in a relationship analogous to a marriage has been longer than a year. That's typically done with the use of a private investigator. And you've got to prove that the relationship itself is analogous to a marriage. So it's not just, people who are dating, people who aren't together at all. It's got to be, a marriage-like relationship. Spousal support can be paid in a lump sum, almost never is, but it can be. Or it could be periodic, which is typically monthly. As I said before, spousal support is no longer taxable to the recipient, nor tax deductible to the payor. If spousal support is resolved by agreement, and if the agreement specifies that it is non-modifiable, it cannot be modified. If it is specified as modifiable, it's obviously able to be modified. There is such thing as what's called a reservation of spousal support, which, let me take a step back. If you waive spousal support in a settlement agreement or in the divorce process, it is gone. You've waived it, bye-bye. However, in lieu of waiving spousal support, and if you don't think that you may qualify for spousal support now, you can ask for a reservation of spousal support. And what that does is you basically say, listen, I may not qualify for it now, but I think sometime in the next 5 to 7 years, whatever that period is, I'd like the right to ask for it because circumstances may change. I may find myself out of a job. And so I'd like a reservation. Now, with a reservation, the duration of that open period is presumptively half the length of the marriage. So again, been married 15 years, you'd have 7.5 years of a reservation where you could seek spousal support. So that's a possibility as well. That's kind of I don't necessarily think I want to ask for it, or I'm not entitled to it now. I don't want to waive it. This is kind of a middle ground. If you seek a modification of spousal support, you've got to prove, like child support, that there's been a material change in circumstances. Doesn't say that here, but not only do you have to prove there's been a material change in circumstances, you've got to prove that that material change in circumstances was not reasonably foreseeable at the time of contracting or at the time of the order. So, if somebody's company is failing and they obligate themselves to a support amount, and then the company ultimately fails, and it was painfully obvious to everyone involved that indeed that was going to happen, that was reasonably foreseeable, that wouldn't be a basis to change it. So that's kind of a reservation and a waiver and modification. All right, custody. Let's talk about vocabulary first. So first of all, there's physical custody and legal custody. Legal custody refers to the right and the ability of the parents to make major decisions regarding the children's education, healthcare, and general welfare. The options there are sole legal custody, pretty rare, when one parent has all the say in terms of those major decisions. Joint legal custody, which is kind of the standard default, which relates to the parties having equal say in a major decision on behalf of their child or children. And then joint legal custody with final decision-making authority, which is more and more popular. And basically that arrangement would be one in which the parties would have equal say, equal input into the decision. But if they cannot make a decision and they're at a total impasse, the party with final decision-making authority would make the decision. Some judges appreciate that because they believe that the child should not suffer and not have a decision made in the event that the parties can't reach an agreement. Other judges don't like it because their perspective is, and I think with some justification, that joint legal custody with final decision-making authority is essentially sole custody, because who's going to repeatedly confer with the other party if they know at the end of the day they can make that decision. Courts want to order joint legal custody unless the parents essentially cannot work together. Physical custody. This relates to where the children physically reside. Primary physical custody would describe a situation in which the child or children live with one parent more than 51% or 51% or more of the time. You will often see shared physical custody, which is a situation in which both parents have the children for more than 90 days per year. That, as I said earlier, begins to impact the amount of child support. And you'll still hear from time to time sole physical custody. That technically is a situation where the non-custodial parent has the children less than 90 days per year. But the courts are trying to get away from some of these what are now considered kind of pejorative terms like sole custody, visitation, etc. So you'll hear a lot more custodial access. You'll hear a lot less of the kind of sole physical custody language, even when one parent has less than 90 days, because of kind of the negative connotation. How do courts decide custody and visitation cases? They look at what are the best interests of the child. I do actually have the code section here, 20-124.3. And I would encourage people with children who have a potential custody case to actually look at this statute. It is pretty important. And the courts have to consider all the statutory factors. At the end of a custody trial, a judge has to say, I have carefully considered all the factors under 20-124.3. And then many cases, they'll go through them and apply them. Ability to attend to the children's needs, that's a factor. Age, physical, mental condition of the children, age, physical, mental condition of the parents, any history of family abuse, other important relationships of the child. Those are all relevant, very relevant factors under 20-124.3. That you'll often hear, and in this day and age, even now, you'll hear a lot of these questions kind of lobbed at the dads, trying to figure out how involved parents are. Questions that you should absolutely know going into any custody situation. Who are your children's teachers? Now, I understand in middle school and high school, that could be upwards of 7 or 8 teachers, but you want to know them. Who are the healthcare providers? Who's the pediatrician? Who's the dentist? Who are their friends? Who are their parents? Who are the parents of their friends? What are their favorite books? What kinds of things do they like to do outside? Knowledge of these kind of basic core facts are early indicators of level of involvement. So if you're answering, I don't know, to any of these questions, learn it. All right. Asset division. So Virginia is what's called an equitable distribution state, to contrast with a community property state. And in an equitable distribution state, including Virginia, the court will apply factors in determining how to divide up the property. So what happens when a court does equitable distribution? And by the way, equitable distribution is just the process in Virginia to classify assets as separate assets, marital assets, or hybrid assets, to value those assets, and then dispose of those assets in some way, divide them, allocate them to one party or the other, etc. The basic rule when it comes to what's marital versus what's separate, and this is very basic, but the basic rule is if the asset is acquired during the marriage and prior to the separation, with a couple of notable exceptions, it's marital. If it's acquired prior to the marriage or after the separation, or it's an asset that's acquired by gift from a third party that's intended only for one of the parties, or it's inherited, it's separate. If it is a little bit of both, meaning, let's say you had a 401k balance of $100,000, you get married, you contribute another $100,000 during the marriage and prior to the separation, then you get separated, and then you contribute another $100,000 post-separation. That is a hybrid asset. The party who is attempting to prove that an asset is separate, well, first of all, if it's a jointly titled asset, the presumption is it's marital, unless, the presumption is it's marital, and any party attempting to prove that some portion of that asset is separate or that it's all separate, it is what's called their burden, which means they've got to prove it. The court's not going to assume that it's separate. The lawyer and that party have to provide the proof, the documentation, the justification of why that's a separate asset. All right. Let's go through some frequently asked questions. You'll often hear, what is a PSA or an MSA or a SPSA? It's not a public service announcement or anything like that. A PSA is a property settlement agreement. It's a private contract between the parties, which, if it's done correctly, it's going to resolve all the outstanding issues between the parties. That would include, obviously, all the things we've talked about today: custody, visitation, child support, spousal support, asset division, what kind of divorce people can file. Can they file on separation grounds? Can they file on fault grounds, etc.? If it's well done, it's going to resolve everything. It's going to leave nothing for the judge to resolve, and it's going to save you a lot of money. And what you typically do then is you file for divorce, and you ask the court incorporate this PSA into a final order of divorce. All right. You are considering a separation, and what should you do first? I always say, before you take that first step of making an appointment with a lawyer, I encourage people to see a therapist, see a religious figure, see other licensed professional counselor, and try to make your marriage work, particularly if you have children. I do strongly believe that divorce should be a last resort. But if you've kind of done those things, or you're not inclined to do those things and you're proceeding with a separation divorce, the first thing I would do is you want to get a comprehensive list of your and your spouse's assets, debts, income. And I would create a journal of events that you feel are relevant to your case, and have that ready before you even see a lawyer. You want to make sure that initial consult or consults, and maybe you want to see multiple lawyers. We'll talk about that in a second, but you really want to have that information ready before you even see the lawyer. So you bring all that stuff to your initial consult. I think it's okay, and possibly, encouraged to see multiple lawyers, because you want to make sure the person is not only knowledgeable, experienced, capable, but is a good fit with you from a working style perspective. And what kinds of things can you ask them, the lawyer at that initial consult, about their qualifications? It's okay to ask, how much of your practice is devoted to family law? What experience do you have with cases like mine? How do your billing practices work? Do you have any references with whom I can speak? The reference thing is a little tricky because, of course, what happens in these kinds of cases is confidential, and sometimes very happy clients will not want to speak with potential clients about their experience, but some will. And every good family law attorney will have a core stable of clients who are willing to do that kind of thing. Do you have a website? Kind of basic things that you should feel very comfortable asking. Now, things you shouldn't ask. What's your record in my kinds of cases? How often do you win? Do you only represent men or women? Do you think you can outsmart my spouse? Those are not particularly helpful questions. I still get them a lot, but that is not necessarily going to give you the information you need when deciding what lawyer to choose. All right, how can I reduce my legal fees? Possibly the most popular question. One thing is doing as much of your own legwork as possible. If you've got source documents, financial documents, documents which prove infidelity, making an itemized and organized list of these relevant documents and contacting other third parties for those documents, that helps tremendously. It's gonna reduce your fees a lot. It's gonna help them. A typical family law attorney may get 200 emails from some rather communicative clients. So culling through all those emails to try to recreate a timeline of what has happened at each custody exchange, that's going to cost a client $10,000. The client has lived it. The client sent those emails. The client themselves could maintain the timeline and save that $10,000. And I say here, keep generally organized records and maintain a journal. That's a great idea. I've got another one here, which is, when you have questions, email your attorney rather than calling them. And I say that because I find in general that an email is going to be more quickly read and responded to. And when I say quickly, I don't mean, is it going to take them 3 or 4 hours to respond? I mean the actual time it takes them to do the response. It's going to be less time than a phone call, because in a phone call, as human beings, we might make small talk. We might ask how the other person's doing. There may be some discussion of, what people did that weekend. The attorney You may develop a wonderful professional working relationship with your lawyer, but you don't want to spend $250 on a Monday morning talking about your lawyer's Boy Scout trip. It is not a productive use of your time and money. So, and those kinds of conversations happen more by telephone than they do by email. Email is usually all business. Lastly, I would say, try your best to be reasonable and civil throughout the process. Understand that you, the client, play a role in your own amount of fees. Sure, you may have an unreasonable adversary. By the way, almost everybody in a even remotely contested separation divorce case thinks that their spouse is the unreasonable one. But if you can look at yourself, try to be pragmatic, try to be reasonable, you're going to save yourself a lot of money. And by the way, never say this sentence. I would rather spend $2 on my lawyer than give my ex-spouse $1. That's just not good math. All right. So I think I am pretty close to the end here. That was my world of divorce, separation and divorce, according to Christian. I know Elise is coming back on. I think I'm a little early. I went a little faster without questions all the way through than maybe I normally do. But
No, I think you covered everything. I appreciate all the things you said about, we tell clients all the time, do your own legwork. Definitely to save yourself money, but also because the more you understand, the more you'll understand the decisions you're making in that process.
That's exactly right. And, I think doing your own legwork and having a good team around you are two of the most important aspects of having a relatively low cost, efficient process. Divorce is never going to be fun. It's never going to be the best time in your life, but there is a way to do this that is low costs, that is efficient and effective. And I think those two things are critical.
Absolutely. Well, I really appreciate you joining us today. Thank you, Christian.
Absolutely. It was my pleasure, Elise. And again, Argent Bridge is fantastic. And we happy to help in any way moving forward.
Thank you.
All right. Take care.